What happens if someone passes away, but they don't need a probate for their estate? How would you go about collecting their personal property? I'm going to answer that for you. My name is Amanda Rocha. I am an estate planning and probate attorney in California. And today I'm going to answer a question that I get quite frequently. How do you collect property outside of probate if probate isn't necessary? Before I get into that, I want to give you my contact information. You can find me on my website, www.amandarocalaw.com. You can comment below if this platform allows you to do that, or follow along on my social media. I'm at Amanda Rocha Law. So you've got someone who's passed away and their estate does not reach the minimum threshold for probate, which in 2023 would be $184,500 worth of assets. And now those assets need to be separate property that is not jointly shared with someone else and not a beneficiary account with a proper beneficiary who is able to receive that. So generally this is personal property, vehicles, art, jewelry, cash in certain accounts that are not jointly held, that kind of thing. How do you go about collecting all of that when someone's passed away? Sometimes what you'll hear from banking institutions or other places is that they want a copy of what are known as letters of administration from the probate court. That's not something you're going to get if you don't have a probate case. So in order to prove to whoever it is that you're trying to collect property from that there is no probate case necessary, certain things can be done. As far as vehicles go with the DMV, if you bring in a death certificate, there is a form you can fill out with the DMV. It has to be no sooner than 40 days after the date of death, and you can prove to them that you are an heir and that there is no probate matter. That's a DMV form that you fill out and bring to them. With other institutions, you can use something called an affidavit for personal property collection or collection of personal property. That is something you can find on the California Judicial Council's website. I will put a link to that document below on platforms that allow me to link it. And basically you fill out this document giving the pertinent information about who the person was, when they passed away, who their heirs are, and then you have that document notarized before you sign it. In front of a notary, you'll sign it. And that is your affidavit, your sworn testimony, basically stating that a probate case is not needed in this matter. You'll provide a death certificate and that document to the institution that is looking for proof that you are doing this legally. Sometimes they'll have their own document that is very similar to that for you to fill out as well. So you really just need to inquire with each institution what it is that they have, if they have a specific document, and if they do not, use this collection for personal property affidavit. Another thing that you might be able to do is contact people who do have joint accounts with them. So maybe they had a joint account with a sibling or a child, and you are wrapping up their estate for them. The person who had a joint account with them and joint access will now be the sole owner of that property. So they can know, if they don't already know, which I'm sure they do, to let that institution know that the other person has passed away, provide them with a death certificate, and then they can have complete control over that property. If there are other items that you are unsure about and they are asking for all sorts of other things, you can feel free to contact me if you're in California. You can find me on my website, www.amandarocalaw.com. You can comment down below if this platform allows you to do that, or follow along on social media. I'm at Amanda Rocha Law.